Hello, everyone, and welcome to the Icon as New Scholarship Showcase. My name is Diego Platz Pereira. I'm part of the Icon as Committee on New Directions in Scholarship, a doctoral candidate at the Universities of Münster and São Paulo, and a research assistant at the University of Göttingen. So today we'll talk about the book, The Language of Comparative Constitutional Law, Questioning Hegemonies, which was very recently published by Hart and Bloomsbury Publishing with its editors Erika Arban, Martje de Visser, and Jong-in Yan. So Erika Arban is a senior research associate at the University of Melbourne, working mainly on comparative federalism, constitutional law and legal methodology, and her PhD at the University of Ottawa received the Governor General's Gold Medal, and she co-convenes the IACL's research group on New Frontiers of Federalism. Martje de Visser is professor of law at Singapore Management University, and she's a widely published scholar in comparative constitutional law and methodology, serves on the editorial boards of Hart Studies in Constitutional Theory and the European Yearbook of Constitutional Law, and co-founded the Singapore chapter of ICONAS. And Jong-in Yan is research professor at Korea University's Legal Research Institute and distinguished senior research fellow at the University of Texas at Austin. Her work focuses on constitutional law and politics, and she contributes to both Korean and international debates, including the Hart series on Asian comparative constitutional law. And she's also a co-chair of the South Korean chapter of ICONS. So Erika, Martje, and Jong-in, thank you very much for joining us. And let's go directly to the first question, which relates to the book's opening chapter. So, why does language matter in comparative constitutional law, and how does it influence the field in practice?
Well, thank you so much. I'll go with the first answer. Law is linguistically sensitive, and as we explained in the opening chapter, language and law are closely connected. Law is composed of language. Law is communicated, is interpreted, and is enforced through language. Of course, the language in question is the legal language, the legal vocabulary, which was created to express the legal concepts developed in a specific context, the context of a given legal system and of a given linguistic setting. Also, legal scholars and practitioners constantly work with legal texts. They analyze, they interpret the legal message or the legal content that the law seeks to convey. But making sense of and understanding legal texts is a demanding task. It is challenging within a single linguistic zone, but the challenge becomes even more pronounced when there is a cross-border dimension. So understanding foreign laws shaped by different social, historical, and cultural contexts and articulated in a different language can be a complex undertaking. But the complexity caused by linguistic differences can go even further. When crossing jurisdictional boundaries, similar institutions or ideas may be termed differently, or the same concept may be understood differently across legal families or cultures. Or there may not even exist an equivalent for a given legal concept in another linguistic zone. All of these barriers affect legal comparison in general and constitutional law comparison in particular. And this is why language not only matters, but also deeply influences the practice of comparative constitutional law.
Yes, that's true. Thank you, Erika. And then we have like a world where we have a strong predominance of English as a lingua franca. And my next question will then be, how has this specific predominance of English shaped the production and circulation of comparative constitutional knowledge?
Yeah, so let me perhaps speak to that question. So I think in terms of the production, what we need to bear in mind is that the toolbox that we often use includes notions and doctrines and principles that are formulated in English that often draw on the experiences of large common law jurisdictions. And one example here we can think of is the notion of a constitutional dialogue, which was very much inspired by the Canadian context with the notwithstanding clause. Now, once we have that toolbox in place, that we suggest gives rise to an expectation, and this may be a silent or even a subconscious expectation, that the English or common law conceptual frame is the preferred lens through which to explore, evaluate, and guide constitutional law and practice elsewhere. And at the same time, this means that theory building and concept formation does not tend to draw heavily on civil law traditions or experiences in the global south. So we get a bit of a mismatch here. Now, in terms of circulation, so moving from production to circulation, what we see is that most of the top journals in the field tend to be in English, even as we acknowledge that there may be exceptions. So ICON, for instance, has a Spanish issue. The New Journal Constitutional Studies accepts submissions in other languages too. But English still very much remains the dominant language. And that may shape the choices made by scholars who want to be published in these journals, because this is important for their own reputation, ranking, citation practices, etc. And their choice to be published in one of these esteemed English-spoken journals may therefore influence the way that they present and conceive of their topic. And then finally, there is a role for education here as well. Many of the US and UK universities are very highly regarded and attract candidates also from non-English speaking jurisdictions. These candidates are then exposed to Anglophone mindsets during their formative scholarly years, and they may continue to apply these kinds of mindsets when they study comparative constitutional law in preference to other ways of thinking about constitutional questions, such as those influenced by what happens in their domestic jurisdiction.
Yeah, thank you, Martia. And you've structured your volume into three main parts. So my next question will be, what was the rationale behind this tripartite organization?
Mm. Thank you. Thank you for asking such an important question. Yes, this book is divided into three parts. The first part highlights issues surrounding language barriers, which are widely acknowledged, but remain insufficiently explored yet, particularly in terms of their methodological and epistemological challenges. The second part turns to more structural concerns, aiming to highlight the epistemic distortions and hegemonic problems arising from the language differences and the use of lingua franca. Importantly, this book not only identifies such problems associated with the languages, but also offers practical approaches to address them. So the last part, the final part of this book, presents ideas and methods on how such challenges have been and can be effectively addressed.
Perfect. I'm gonna pick up on something you just told us, Jong-in, like this practical approach. So my question will be, beyond diagnosis, what practical strategies de facto would you recommend for scholars, for students, legal practitioners, such as judges, lawyers, or policy makers, to overcome those language barriers in comparative work?
Yeah, thank you for the question. Beyond diagnosis, in the book, we suggest at least 5 strategies that can be adopted to pluralize the discourse. The first strategy is investing in the production of translated work, including the translation of excerpts of judgments by apex courts and of scholarship by contemporary constitutional thinkers. Now, this type of translation, we argue, should be contextual, ideally done not mechanically, but by scholars who understand linguistic nuances and who understand the specific context. Second, we suggest to create opportunities to disseminate scholarship in languages other than English, including at venues or through avenues that are typically used for the circulation of scholarship produced in English. As Marce was saying early on, something has been done in this regard. Some international public law journals now accept non-English articles. Some associations like ICONES in the past have allowed panels in a foreign language, but perhaps more can be done. And English-centered journals should promote the inclusions of abstracts in a foreign language. Conference organizers could support non-native speakers to further inclusivity. Of course, it is also important to make sure that the use of non-English languages in such global fora does not become itself a barrier to knowledge transfer, with only those able to speak that language that participate in the discussion. But if a decision is made to retain English as the lingua franca, then journal editors, reviewers, conference organizers should better accommodate non-native users of English. A third strategy, we suggest to ensure inclusive citation practices in constitutional law scholarship. When preparing scholarship in English that focuses on non-Anglophone jurisdictions, there should be an effort to feature citations to works in the language of those jurisdictions. In doing so is in part a question of epistemic justice, because this practice recognizes that there exists a national discourse that the author is inspired by and building on. Citations to non-English materials could also play a guiding function, introducing readers to new materials that they may wish to continue to explore in their original language. Fourth, we suggest to embrace being conversant in more than one language. This prescription deserves to be reckoned with, and with a reciprocity, so that it does not fall only to non-native English speakers to become familiar with the lingua franca, but that native speakers too experience the costs, the challenges, but also the rewards of being at least bilingual. And finally, we suggest partnering with foreign language speakers. To the extent that English remains the lingua franca, then it should be incumbent on non-native speakers to try to reach out and include foreign language speaking colleagues in their scholarly networks.
Yeah, that's great. I would like to, in the next question, address the third point, perhaps something also of the fourth point you mentioned, Erika. And my next question will then be, what specific advice will you give to scholars who write in English about constitutional systems that themselves operate in other languages? And in other words, I'll specify, how can comparative constitutional scholarship be shaped so that it both reaches this broad global English-speaking audience and remains meaningful for readers from the non-English speaking jurisdictions under comparison?
Yeah, so we think that that is actually a critical challenge, and a challenge that's particularly pronounced for scholars that are not from or based in the constitutional system that is the subject of analysis. So the ones that can be considered outsiders, to put it like that. So what we can do in this regard is put forward 4 suggestions. The first is to be mindful that the same concept in English may have a different meaning in another context, which is something that Erika mentioned earlier. And here we can just think of a simple example, such as the rule of law, or rechtsstaat, or état de droit, or rechtsstaat in Dutch. So we can have multiple terms that would all be translated into English as rule of law, but would cover slightly different content with different conceptual connotations as well. So one good practice here would be to retain the foreign expression and use the English terminology in brackets. Because when we do that, we clearly reference to the reader that the concept remains a foreign one that is embedded within and that may reflect different legal as well as extra-legal environments. Now, the second, and this is one that we very firmly believe in, is practicing modesty. And that means that when you formulate conclusions about the functioning of a non-English speaking jurisdiction, you don't make these bold claims without sufficient supporting evidence, but that you are perhaps a bit more tentative or hesitant in the way that similarities and differences, notably with usual suspect jurisdictions, are cast. And then the third picks up on something that Erica just mentioned, which is that idea of a partnership. So, what we believe is critically important is investing in collaboration with local scholars. So, scholars who have grown up in, studied in the constitutional system that you want to explore, and who therefore also master the foreign language. Now, these local scholars can be asked to critique the description and analysis that you have given of that foreign legal system. But what is even more important, perhaps, is to actually co-author with these individuals so that we can embrace dialogue not just as a constitutional term, but as a methodology, as a way of doing scholarship. And then the fourth, and this is specific to scholars who hail from non-English speaking jurisdictions, it may be important to have a cognitive shift in that they should accept the confidence to conceive of their account of their jurisdiction as being inherently valuable. So without the need to have this extensive justification of saying, it is important or fascinating to look at Bhutan, even though we don't normally do this, there are good reasons and ample justification, etc. So they should present their jurisdiction on their own merits and using an accepted local lens to present this jurisdiction, because doing this enriches the English discourse, but it also underlines familiarity for scholars who hail from that foreign jurisdiction.
Yeah, in this sense, in several chapters of the book, you discuss untranslatability. So within these tensions that you've just explored or drawn for us, how can comparative constitutional law then reconcile the search for shared categories with the need to respect this context-specific vocabularies and meanings?
Very good question. This is very important from an academic perspective. I think scholarship and research must be very sensitive to concepts and terminology and to the nuances they contain. However, we always and often overlook the fact that such academic concepts and terminology originated in different linguistic contexts. As, as English became the lingua franca and academic concepts and terminology from the scholarly mainstream countries became universally accepted, concepts and terms originating from specific cultural and the political and geographical and social background often failed to be properly understood in other regions. Thus, it resulted in their misinterpretation and distorted adoption. Conversely, academic concepts and terminology from local context frequently fail to be properly shared with the wider world. So in such cases, we commit the error of describing the same phenomena using different terminologies or describing different phenomena using the same terminology. Several chapters in this book address such cases. For instance, even though Marche previously presented a very interesting example of the rule of law, South African term Ubuntu has a distinct meaning that cannot be substituted by the Western concept dignity. In Italy, in case, forma di stato, right? Forma di stato cannot be accurately rendered by the English expression state form. Specific institutions, for example, such as Amparo, also present this problem structure. So that is, we must recognize that we sometimes or often do not have shared categories. So there may be merit in accepting the terminology as it is in a given jurisdiction, even if there is no counterpart in other jurisdictions. Therefore, we need to be interested in categories specifically developed in other jurisdictions, and it will eventually enrich our field with more diverse constitutional knowledge.
Yeah, that's great. And I'm going to push the discussion also want to shed light on another topic, which is what insights does the book offer about the role of language in shaping constitutional law, also in post-colonial and multilingual contexts? Multilingual, I mean like EU or something like this. What you can say about the role of language in these contexts?
Very, very good point. I might answer. I can answer. Part two of this book contains a chapter addressing linguistic issues within a post-colonial context, and several chapters of part three deal with technical challenges in a multilingual context, particularly the issue of recognizing and accommodating the diverse official languages of the European countries within the EU, of several implications for the landscape of comparative constitutional law. It highlights the importance of creating an environment where multiple nations are treated without discrimination equally and are more inclusive, while also presenting the technical methods to achieve this. However, it also demonstrates that this approach still has technical limitations and even can increase the complexities in dealing with the problems, and also it may expose costly problems. Such pros and cons arising from the coexistence of multiple languages between nations with different linguistic backgrounds can also apply when a single country adopts a multilingual policy. Moreover, if that country has a historical context of a colonial rule, which led to a hierarchical existence between the language of domination and local languages, the issue may become more complicated. So we should also consider situations where the political hegemony enters through the language in this context, complicating the constitutional landscape and its realization within the given jurisdiction, and creating a disconnect from reality. So I would emphasize that without properly understanding this context of a given country, comparative constitutional scholars from the outside world may risk failing to properly understand the constitutional system and the knowledge of that particular country.
Okay, and looking ahead, how might emerging technologies like machine translation or AI reshape also comparative constitutional research?
Yeah, I think that's sort of the elephant in the room, right? Where we all think the onset of AI may be a real bane in this regard, or may be a real boon in this regard. So on the one hand, we can say, look, if we have the availability of machine translations and AI, that holds out the prospect of making texts produced in non-English speaking jurisdictions readily available in a much shorter period of time than when we are reliant on human translations. Now, that in turn means that the discourse can be enriched along a range of dimensions. First, geographically, by expanding the range of countries that we may feature in the discourse, in particular those that don't have English as their main language. Second, and relatedly, we might be able to go beyond court centricity because we have the possibility of translating legislation, soft law, policy documents, and by expanding the range of materials, we might arrive at a more holistic understanding of the constitutional system in question. And then scholarly, and that goes back to a point that we mentioned earlier as well, it may expedite translations of scholarly works that have been produced in other languages, thereby bridging, for instance, the English with the French, the Spanish, the Italian, the German discourses, and infusing the English-speaking discourse with new concepts, perspectives, and ideas. So there is much to be hopeful about. But at the same time, in the opening chapter of the book, we do sound a note of skepticism too. And that's because we believe that these benefits may not always materialize and that challenges may remain. The most important of these is that law is culturally and contextually specific, and the various nuances may not always be captured well by technology, so that we have a risk of misinterpretation of foreign law. And that's amplified when we're dealing with these untranslatable concepts like Ubuntu or forma di Stato. More importantly, or more in addition, perhaps, you have the prior step of identifying what should be translated. And that's a decision that requires the comparators to have some knowledge of understanding that foreign legal system so that they can navigate towards the legal materials that they want to feed into the AI system for machine translation. So you still require some degree of linguistic knowledge about the foreign legal system. Then there are questions of resources and epistemic justice, because we can't assume that every single comparative constitutional scholar has access to a stable internet connection, a well-functioning device, or even a paid subscription to one of these superior machine translation tools. And then finally, perhaps, there could be an hegemonic imbalance due to the material that has been used to train the AI tool. So we might see a replication of certain hegemonic traits when you feed in new materials. So in short, we believe that the human processing of information, as well as the positionality of scholars, remain critically relevant even in an age of AI.
That's really interesting. Thank you, Martia. So we did some looking into the future, and now looking back, what were the main challenges that you faced in bringing this volume together?
Yeah, that's a good question. First of all, let me say that for the three of us, it has been a wonderful experience to work with the publisher, with Heart. We are incredibly grateful for their continuous support and also for believing in this project since the beginning. And we're also so grateful to all the authors for their excellent contributions, for the diverse perspectives and insights that they brought to the book. But talking about challenges, when we were bringing the volume together, I think that the main challenge we had was in a way the result of the interest that the topic itself triggered. In other words, the book could have been at least twice the actual size because of the interest it raised. But due to a concatenation of factors, including time issues, space constraints, challenges in finding the right authors to contribute, we were forced to limit its content. But there were many other topics that we would have liked to include or discuss in the book, and we had to exclude. So hopefully we can continue the conversation in another publication.
Absolutely, absolutely. And finally, if what would you say if readers were to take away just one lesson from this book? What would you hope it to be?
Well, I guess one takeaway lesson is that even if English is used as the lingua franca, the communication language, scholarship on common law English-speaking jurisdictions should be seen as a regional scholarship, not as universal, as we also said previously. And this is linked to the question of how truly comparative is comparative constitutional law as it currently stands. For all the reasons that we discuss in the book, the hegemonic use of English as lingua franca of the discipline means that a very limited number of countries are normally treated in mainstream scholarship. Consequently, except for the usual suspects, the great majority of countries rarely, if ever, feature in such global conversations. And in turn, this is also tied to the fact that until now we have considered comparative constitutional law as a monolingual discipline, but we are wondering whether it is perhaps time to rethink this and make it a multilingual discipline.
Yeah, I would perhaps add to that as we describe also in the opening chapter, language has often been an invisible aspect of comparative constitutional law, where people seem to not really think about it. If it is acknowledged in books about how to do comparative constitutional law, it's mentioned in passing as perhaps one of these issues or challenges one may need to reckon with, but one that isn't explored in great detail. So I hope very much that the book will help to begin to change this so that whenever someone writes a comparative constitutional piece of scholarship, linguistic considerations are of paramount relevance in shaping the design of the project, in presenting the findings, and in thinking through what it means for the conceptualization of the issues that have been identified. So also linking back to what Erica just mentioned, if we are more mindful of language as a visible problem and a visible challenge, it might bring us back to a degree of modesty in the way that we practice our discipline.
As Erica properly pointed out, the topics in this book is not exhaustive. But as this volume speaks out, the issue of language in comparative constitutional law is not merely a matter of the regions and languages that have been restricted from or less engaged with the mainstream scholarship. Rather, I'd like to emphasize that it is a problem that concerns the entire scholarship and everyone. Whether we realize it or not, our entire field of comparative constitutional law might have committed serious epistemic distortions and methodological errors. So I wish to emphasize that we must all pay more serious attention to the issue of language and also work to resolve the challenges together.
Yeah, thank you so much for your wonderful work and also for this interview. I guess everyone that's hearing it has another questions popping out, and so I invite everyone just to read the book, take a look into it, and yeah, thank you so much. Take care.
Thank you. Thank you so much
Thank,
for having
Thanks
us
so
here.
much.
thank you. Thank you.
You're welcome.